This is a presentation about the Performance Audit Report on Criminal Justice System Prison Sentences, Report Number 4 for financial year 2016-17. Please note this is a summary of the report to Parliament. The full report can be read on our website. This is the first of two reports from our criminal justice audit. The second report is to be tabled in Parliament in early 2017 and focuses on the integration and reliability of criminal justice data. This audit examined how well the Queensland adult criminal justice system exchanges and records data to calculate and administer prison sentences accurately. We focused on the public sector entities carrying out sentences. We did not consider the decisions and sentences of magistrates and judges as part of the audit. The majority of prisoners are detained and discharged in accordance with their sentence. Nevertheless, sentence errors do occur. There are two effects of these errors. The prisoner is released into the community before they are supposed to be, which is called a discharge in error, or the prisoner is held in prison longer than their sentence allows. This is called an unlawful detention. Because of the adverse consequences to the community, individual prisoners and their families, criminal justice entities must address these errors in a manner that prevents further occurrences. Data reported in this audit is the result of information we collated from various sources across the Queensland Police Service and the Department of Justice and Attorney General, including the Queensland Courts Service and Queensland Corrective Services. It is the first time all of this information has been brought together to provide a fuller understanding of discharge and detention errors. This figure shows the number of discharge errors in red and unlawful detentions in grey for the financial years between 2004-5 and 2015-16. The black line shows the overall trend over this period, and the stars represent reviews within corrective services in 2009 and 2014. These reviews were aimed at identifying the cause of these errors and how they might be addressed. The figure shows that the total number of discharge and detention errors has increased since 2004-5, and it means that these errors are more frequent now than they were in the past. Also, the errors more commonly result in prisoners being held unlawfully than being released earlier than they are entitled to be. This figure shows that between 2004-5 and 2015-16, the rate of errors per 1,000 prisoners managed has increased. The total number of discharge and detention errors is increasing at a rate greater than the prison population. This indicates that the increased number of errors is not solely attributable to prison numbers. Prisoners unlawfully detained between 2004-5 and 2015-16 were held for an average of 15 days, and this ranged from 1 day to 313 days. The prisoners discharged in error were released 51 days earlier on average than they should have been, and again this ranged from 1 day to 963 days. However, this does not mean that in all cases the prisoner actually spent that amount of time in the community. For example, the prisoner discharged in error 963 days early was at large for 35 days before being returned to custody. Process and communication errors accounted for 73% of discharge and detention errors. These errors primarily involved issues with entities sending, receiving, or actioning sentence information. Data entry issues accounted for a further 15% and inaccurate sentence calculation for 12% of errors. The number of errors has fluctuated from year to year, but the overall trend is increasing. The gaps we identified in detection, quality assurance, recording and reporting processes indicate that further errors beyond what we have collated from entities' records may have occurred but gone undetected. Criminal justice entities do not record and manage sentence errors in an integrated way. Instead, each entity follows its own approach and only records, reports and addresses those errors they attribute to themselves. This means they lack a complete understanding of the root causes of errors in calculating and administering sentences. We concluded that without this, and a whole of justice system improvement approach, any new attempts at preventing errors are unlikely to be any more successful than previous efforts. We made 5 recommendations. We recommended the Department of Justice and Attorney General, in collaboration with the Queensland Police Service, better integrate the sentencing administration processes and quality assurance across the criminal justice system. Formalise, implement or update where necessary policies and procedures. Assess the need to review relevant sentencing legislation. Ensure the appropriate capacity, capability and training of staff responsible for sentence calculation and administration across the criminal justice system. Improve the accuracy and level of detail recorded about discharge and detention errors, that they consolidate the recording and reporting of the errors within and across the 3 entities. Thank you for listening. We trust this presentation has been of value. For more information on the issues, opportunities and recommendations highlighted in this summary presentation, please see the full report, Criminal Justice System Prison Sentences, on our website under Reports and Resources at qao.qld.gov.au.